Hi, my name is Mark Biernath. I'm an estate planning attorney here in the Atlanta area with a special emphasis on special needs planning. And I've received a few questions that I'd like to respond to. We have $10,000 in a UTMA account for our son. He has a developmental disability and we want to apply for SSI. He just turned 18. Will this money prevent him from getting SSI? First off, we need to understand a little bit about what a UTMA account is. A UTMA account at one time was used primarily as a college savings vehicle, where people would set money aside for minors in order to save for college. Sometimes they're set up by grandparents making gifts to minors. Sometimes it's parents who set money aside in order to provide for future needs for a child. One of the problems with the UTMA account is by law, on a certain date, usually it's the 21st birthday of the child, that money becomes their property. Before that time, the UTMA account or UTMA funds are held by a custodian. So oftentimes you'll see on the account title a parent's name for the benefit of, or FBO, and then the child's name, and then usually somewhere in the title it will say either UTMA, UGMA, and then there'll be a number either 18 or 21. Because there are some older accounts where the UGMA or UTMA funds are held only until the 18th birthday. The way Social Security views this money is very important when you're in the process of applying for SSI. Social Security will not count that money as an available resource as long as the beneficiary is under the age of 21. So if you have money in a UTMA account, you can go ahead and apply. It should not be counted as an available resource. And in fact, there are POMs. POMs are the Program Operation Manual guidance for the caseworkers that specifically address UTMA funds and tells the program administrators that these funds, so long as the beneficiary is under the age of 21, are not a countable resource. You should use it up. You must use it up prior to the 21st birthday if you want to maintain eligibility for government benefits. Now, there are many ways you can use that money. While the child is under the age of 18, mom and dad have a legal duty to support their children. And so generally we don't like using UTMA funds to provide for the basic necessities of life. Food, clothing, shelter, the things that we deem as basic needs. However, anything over and above basic needs, things like vacations, summer camps, therapeutic opportunities, those are things that you can use UTMA funds so long as they are benefiting the person whose money that is. Keep track of that, keep records of that, because if Social Security is already aware of the UTMA account, you are going to have to account to Social Security where the money went. Best way to do that is keep receipts and be able to show we spent $2,000 on a trip to Disney World. We spent $1,800 for this summer with 6 weeks of summer camp, and be able to show what you're using that money for. Now, there's a unique opportunity when you have a child between the ages of 18 and 21, because the money is still a non-countable resource in that UTMA account, but they're over the age of 18, so mom and dad no longer have the legal obligation to support that child. So if that child is living with you at home, you can charge them room and board. Now, if they are already receiving SSI, there's a little wrinkle to this, because every month you pay for room and board, it'll either be counted as income, so the money coming out of the trust will be considered income for the beneficiary, therefore their SSI will either be reduced or perhaps eliminated depending on how much is coming out of the trust, or it may be considered in-kind support. And this is another concept that we're going to address in another video. However, in-kind support is where someone else is providing housing or food for the beneficiary, in which case Social Security is saying, well, if someone else is providing for it, then we don't need to provide for it. So those are some things you need to look at. Ideally, you have that money spent down and out of the UTMA account prior to the 18th birthday, but if not, you do have this window of opportunity where you can work it down. It's got to be gone before the 21st birthday. If it's not gone before the 21st birthday, then benefits will be in jeopardy, simply because by operation of law, that money now belongs to the child. I hope that you find this information helpful, and if you have any questions or comments, we welcome you to post those. If you're on YouTube, just use the comment section below, or if you'd like to send us an email with a question or a comment, please send that to Mark, M-A-R-K, @biernathlaw.com. We welcome all your comments, and we hope to be able to respond to many of them. Obviously, if we get a whole bunch of responses, we may not be able to respond to each and every one of them.